Hello everyone, this is day 53 of Polity Daily Drill. Let's begin. First question. The concept of Indian citizenship came into existence after the Government of India Act of 1919, after the Government of India Act of 1935, on the day the Constitution was adopted by the Constituent Assembly, or on the day the Constitution of India came into force. So, of course, we know these two are incorrect. It all boils down to either C or D. So, what is the day on which, or the date on which the Constitution was adopted, enacted? This was the 26th of November 1949. However, the date of commencement of the Constitution is the 26th of January 1950. Right? This is what is known as the Constitution Day, and this is, of course, celebrated as a Republic Day in the country. Now, if you read the provisions of our Constitution, you can understand that citizenship and some other provisions pertaining to elections, primarily provisional parliament, temporary and transitional provisions, and title, etc., they came into force on this date. So, articles like Article 5, 6, 7, 8, 9, which all deal with citizenship, came into force on this date. And some other articles also, like elections 324, 366, 367, etc., they also came into force on the 26th of November itself. The remaining provisions, the major part, almost 95% of the Constitution, that came into force on 26th of January 1950. Thus, the concept of Indian citizenship came into existence on the day the Constituent Assembly adopted the Constitution. Right answer is C. Next question. Consider the following statements. The President and the Governor are immune from criminal proceedings in any court during their term of office. Yes or no? This is correct. Why? This is Article 361. Right? Number 2. Foreign sovereigns, ambassadors, and diplomats are immune from civil proceedings but not from criminal proceedings. Now, actually, this is wrong, because if you refer to the Vienna Convention, you will find there is an Article 31 there. So, according to Article 31 of the Convention, a diplomatic agent shall enjoy immunity from criminal jurisdiction of the receiving state. Of course, he shall also enjoy immunity from civil and administrative jurisdiction as well. So, both civil and criminal. Okay, so 2 is wrong. Number 3. Members of a state legislature are not liable to any legal proceedings in any court for anything said or any vote cast in the legislature or its committees. Article 194, it is just like parliamentary privilege. The same privilege extended to the what? The same privilege is extended to our MPs. Anyway, so 3 is correct. How many of the above statements are exceptions to the principle of equality before law under the Indian Constitution? So primarily 1 and 3. 2 would have been, but since it is incorrect as a statement, incorporating it here would be wrong. B, only 2 is the right answer. Moving on to the next question, question number 3. Which of the following constitutional provisions aim to achieve the objective of political equality? So see, the idea of political justice, political equality ensures that all individuals have an equal, free and fair right to participate in political opportunities. This would of course mean without any discrimination, equal access to political offices, equal participation in governmental processes, etc. Let's read. First one. No individual shall be deemed ineligible for inclusion in the electoral rolls based on religion, race, caste, or sex. Absolutely correct. And of course, a part of political equality. This is nothing but Article 325. no concept of separate electorate on the ground of either religion or race or caste or sex or gender. One is correct. Elections to the Lok Sabha and the assemblies shall be conducted on the basis of adult suffrage. Yes, this is also correct. Article 326, the idea of universal adult franchise voting rights for all. Meaning what? Of course, we have the criteria of age, but beyond that, voting rights for all the citizens. So that's the concept. So 2 is also correct. Number 3, there shall be equal opportunity for all citizens in matters related to employment under the state. Now see, equal opportunity for all citizens in matters relating to employment or appointment to any office under the state. So this would mean what? It clearly says that no citizen shall be ineligible for or discriminated against with respect to maybe say any aspect. However, Article 16 implies that there is equality of opportunity in matters of public employment. Please understand, we are focusing on the political equality aspect. Yes, this is Article 16, I fully agree. However, the idea is political equality. This is what is called a civic or a civil equality, civil liberties. So it is not a part of political equality. Statement is correct, but not a part of this. So 1 and 2 are right. This means right answer is A. Question number 4. Consider the following statements. Statement 1, a bill to amend the preamble to the Constitution of India cannot be introduced in the Rajya Sabha. This is wrong, because any kind of bill to amend the Constitution called the Constitution Amendment Bill, it can be introduced in either house by any member, meaning either a minister or a non-minister, who we also refer to as the private member. So 1 is wrong. If statement 1 is wrong, we'll have the answer. Statement 1 is incorrect, 2 is correct. Right answer is D. Let's read the second one. The Supreme Court in the case 1 in the Bharati case held that the preamble is a part of the Constitution and held that the preamble can be amended subject to the basic structure doctrine. This is of course correct. Preamble is a part of the Constitution. It can also be modified, but you cannot modify those elements of the preamble which are a part of the basic structure. And the last question for today. The right to default bail if the charge sheet is not filed within the stipulated time is guaranteed under which article of the Indian Constitution? So see, according to section 167 subsection 2 of CRPC, subsection not important, an accused is entitled to default bail if the investigating agency fails to file a final charge sheet within 60 days of the remand. 60 days. Now see, the stipulated time of 60 days can be extended to 90 days also for certain categories of offenses. That's there. Anyway, so last year in the Ritu Chhabadiya case of 2023, the Supreme Court said that the right of default bail under section 167 subsection 2 of CRPC is not some statutory right. It's not merely a statutory right. It's a fundamental right that flows from Article 21. Okay. So this is the idea that is there to prevent or to protect the accused persons from this unfettered and arbitrary power of the state. Right answer is C, Article 21. This brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that's all for me. Jai Hind.